Chapter 2, Company Formation. In this chapter, you are going to study the process of forming a company, and keep in mind that the type of companies mentioned here is company limited by shares, not unlimited company or any other types of corporations, because as I have mentioned in chapter 1, companies limited by shares are the main subject of research in this course, and they are the subject that are regulated by the majority of articles of the Companies Act 2006 of the UK. We are now in part 1 of this chapter. First, I want to introduce to you some basic steps of registering a company. Step 1. The founders of the company will prepare registration documents. These documents are required by the Companies Act. Then in step 2, they will submit these documents to the Registrar of Companies. The Registrar of Companies is the state agency that is in charge of recognizing the existence of companies. When step 2 is done, the companies will be conferred a certificate of incorporation. Then moving on to the final steps, which is called post-registering. At this time, the company has already come into existence. It's time to open the company's account or obtain the corporate seal, and it's time for the shareholders to officially contribute capital. Section 1060 of the CA 2006 provides you with more details on the Register of Companies. There are Register of Companies for England and Wales, for Scotland, and for Northern Ireland, and which Register of Company that the registration documents must be delivered to depends on the intended location of the registered office of the company. And then in the next point, you see the method of forming a company. A company is formed by one or more persons subscribing their names to a memorandum of association and complying with the registration requirements. Memorandum of Association, khế ước thành lập, is a very important and mandatory document, something that the law on enterprises in Vietnam does not require, and we're going to have a deeper analysis on this document in the next slide. There is a list of documents required for registration in the handouts that I sent to you through emails, so check your emails for the full list. Here I want to notice you some points about the Memorandum of Association, or the MOA. According to Section 8 of the CA 2006, the MOA contain only the names of the initial subscribers for shares and their agreement to form a company. However, prior to the CA 2006, the predecessor CA in the old time set out much more information of company, such as name of the company, place of incorporation, objects, liabilities and rights of the shareholders and the directors, and also the share capital. Information like the rights and liabilities of shareholders and directors and the share capital fall within the contents of the Articles of Association. Articles of Association, điều lệ, has always been the document that deals with the internal management of a company. So there is no need for the MOA to contain the information that are already in the contents of the Articles of Association. So nowadays, the CA 2006 regulates the MOA in a very much shorter way. Remember, the main function of the MOA is to show the initial number of shareholders so that we can calculate the initial share capital of a company at the time of formation. After the process of registration, a company will be given a registered number, which appears on the certificate of incorporation. Remember, a company's name may be changed during its existence. However, a registered number never changes. Company registered numbers help avoid identification difficulty arising where a company enters into an agreement and after that changes its name. Then its name is used by another company. You see, company registered numbers help us to identify the correct company even after it has changed its name. And now let's talk about company names. A company may have a business name different from its official name. For example, as you can see here, a company with the official name as Gas Appliance Limited can trade under the business name as Flames for You. The reason for a company to have a business name is that the business name may be friendlier to the customers or easier to remember or more catchy and impressive. The company name of any company has to be in compliance with the rules set out by the CA 2006. In the next following 4 slides, you will see the situations where a company name is refused to be registered by the Registrar of Companies or directed to be changed by the Secretary of State. One more issue relating to company names is the issue of passing off, which can be found in case law. Now, I want you to look into the case of Irvin Warning v. J. Townend and Sons and try to answer these following questions. You can find the answers for these questions in the following 4 slides, but be sure to work on this by yourself first. As for business names, the basic rule is that business names are not registered with any government department, but there are a number of provisions in the CA 2006 that regulates the business names of companies. In this slide, I show you the significance and meaning of the Certificate of Incorporation. You need to take a look at Section 15 of the CA 2006 to see the contents of this certificate. Basically, companies can move on to commencement of business after receiving the certificate of registration. However, the commencement of business can be different between private companies and public companies. A private company may start its business as soon as the certificate of registration is issued, but a public company cannot conduct business unless it has obtained a trading certificate from the Companies House. The trading certificate is a document confirms that the company has the minimum allotted share capital. In the next slides, you will see the minimum allotted share capital required by the CA 2006. Here, I have a little question for you. Can you find the reason why public companies are required to have the minimum allotted share capital of £50,000? In part 2 of this chapter, you are going to discover the roles of promoters and pre-incorporation contracts. The term promoter is a term of business and not of law, so you cannot find the definition of this term anywhere in the CA 2006. The definition that you are looking at right now is the definition used commonly by the scholars in the field of business and in the field of law. Also, be sure to see your handouts for the main functions performed by promoters. As you can see from the promoter's main functions in the handouts, this type of persons act as agents of their company, so that is why they owe a fiduciary duty to the company, just like any other agents owe the fiduciary duty to their principals. Section 51 of the CA 2006 gives you the general rules on the duty of promoters, and the manifestation of these general rules can be found in case law presented to you in the following few cases.